The number of witnesses has only increased over the years. Since 1971, there has been enough witnesses to triple the amount of students at CCC&TI. The student-to-staff ratio is 17-1, with 335 staff members, which means there are 6,000 students. There are billions more who have not reached out for help or been a witness, but they have assisted in a court trial. Despite the beliefs of many, witnesses are very important, especially to the jury and to the client in which the witness is testifying or testifying. So, despite a person's age, race, gender, or financial background, if there is an appropriate reason to have a witness, the client has the constitutional rights to try to best protect themselves in their trial. I consider myself credible to talk about the importance of a witness because ever since a young age, I have been witnesses from several trials. Also, I grew up in a family where my mom is a lawyer. She has taken in considerable amounts of time to prepare and to question witnesses. I also thought I might want to be a lawyer when I grew up as well, so that led me into lots of research. Through that research, I had to research witnesses, and I became very intrigued in what the process of becoming a witness and what resources were out there for witnesses during trial. So now that I gave you an overview, let me tell you how a witness can be considered credible or non-credible. A prospective witness can be either destructive or productive. Witnesses can have more value in a trial than evidence. A witness does not necessarily have to see or hear something whenever the event took place. A witness could be someone who is able to talk on DNA samples, or they could have specific value. According to Hyten, a lawyer, author, and editor of Lawyers.com, and a researcher for many other law-related research studies, he says, sometimes a witness is the only source of a critical piece of information. Even when there's also physical evidence, witnesses are the storytellers who can explain the evidence and create a coherent narrative that convinces the jury. A jury or judge takes much consideration into the accounts that were given, and without the accounts missing gaps or important info would not be able to be considered in the court's verdict. The courts also will question the witness's competency before they are allowed to testify. So, you may be asking, what is a verdict? A verdict is the final decision made by the court, sometimes made by the judge, and also sometimes made by the jury. The verdict is to tell if the events that were presented to the court are considered true or false. You may be also wondering, what does competency mean? Competency is how able one is to be efficient and effective while giving their testimony or while being questioned. So secondly, witnesses can and will be used by all parties involved in the court proceeding. A witness and their testimony can be used by all, meaning that not only the side that they were called in by will only be using them. It is important for each side to be able to question the witness and hear their testimony. Therefore, that is what makes the trial partially fair. To avoid surprises at trial and to know which witnesses to call to testify, the prosecutor will depose critical or expert witnesses to find out what they may say during a trial and potentially preserve their testimony. These conversations will help the prosecutor decide who to call as a witness in court. And according to the Department of Justice, the highest federal department that focuses on all components of law since 1870, one of the first steps in preparing for trial is talking to witnesses who could be called to testify in court. A witness is a person who saw or heard the crime take place, or may have important information about the crime or the defendant. You may be wondering, what does depose mean? Depose means for a client to be questioned by a lawyer at a certain time, place, and format before they testify during the trial. So, to show who may use a witness and how much they may use the witness, I have a pie chart. And in the pie chart, it shows the blue, which is used by the prosecution, which is 63%, the yellow, which is used by Chambers, and that's 2%, and the red, which is defense, using 35%. Chambers can be made up of just your district judge. It can also be made up by a judicial office of a higher federal authorities. So, continuing that thought, witnesses will need to be protected. When studies have been conducted, the importance of a witness has been essential to the jury. The statements also have led to a large percentage of convictions. Out of the capital punishment cases in which went to trial, 46% convictions were based on witness testimonies. According to Nuance, the author of Law and Human Behavior, Volume 32, the Sixth Amendment, this clause is supposed to protect the rights of the accused by allowing effective cross-examination of the cooperating witnesses and promoting the jury to consider the motivation of the witness. The marshals are a safe way to let witnesses prepare for trial without biases of others, and also give protection to their testimony. According to the U.S. Marshals, a federal-level judicial law enforcement agency who specializes in the protection of judicial happenings since 1789, the U.S. Marshals Service provides the security, health, and safety of government witnesses and their immediate dependents, whose lives are in danger as a result of their testimony against drug trafficking, terrorists, organized crime members, and other major criminals. The United States Marshals have protected, relocated, and given now new identities to over more than 8,600 witnesses and to 9,900 witnesses and family members. So, in conclusion, the importance of a witness is very critical. The main components that I mentioned today were a perspective. Witnesses can be productive or destructive. A witness and their testimony can and will be used by all parties involved, and a witness and their testimony will be protected. Despite the beliefs of many, witnesses are very important to everyone, especially the jury and the client that witnesses is either testifying for or against. Even though all trials may not use a witness, it does not make them less effective. Witnesses are extra factors that carry a lot of weight in the trial. Now that you are better informed on the importance of a witness and the protective resources out there for a witness, I urge you the next time that you are watching a judicial television show or that you are called to testify yourself, to keep in mind the key factors of becoming a witness.